Mr. Williams?
Yes, good afternoon, Your Honor. How are you today?
I'm well, sir. How are you doing?
Doing very well. Judge, I have one client there, Henry Lee Davis. He's in your jury box over there. He should be.
Okay, Mr. Davis.
So, with State of Florida versus Henry Lee Davis, Your Honor, I have two case numbers, 24 CF 42 and 24 CF 59. Your Honor, we're presently on a trial track for that October 28th date. Mr. Davis has rejected the state's offer at this point, which was the lowest permissible sentence offer. So I just request that we stay on track and maybe come back on that 10/25 for another trial management in case we have a resolution.
Okay, so we'll see for a trial. Yes, sir.
Open court. Okay, he's not representing me properly. I don't feel like I'm being represented properly by him. That man is the man that said, "Oh, just take the charges, just take it. You did it, whatever. Just be done with it. Just be okay. Just this is low permissible." I've read up on it, and it says not exceeding within 5 years on the charge of third-degree felony. This man saying, "Oh, you just they can give you 10 years. The charge holds 10 years. Just take 5, and you'll be okay." I don't feel like he wants to represent me. I don't feel like he's willing to represent me. I don't feel like he's capable of representing me.
Buckle up, guys. Today we're diving into a courtroom drama that's anything but ordinary. In this opening scene, the tension is already brewing. The attorneys lock horns right away, and the judge wastes no time establishing control. What seems like a calm start quickly reveals the heat simmering underneath. This isn't your average day in court, and you're about to see.
So you'll raise your right hand.
Yep.
And everything you told me, Mr. Davis, is true and accurate to the best of your knowledge. You're asking that I discharge Mr. Williams?
Yes.
But if you want me to discharge Mr. Williams, what I'm going to do, I'll ask Mr. Williams a few questions. And if I don't find that he is rendering ineffective assistance of counsel, you can still discharge him if you want, but the state will not be required to give you or provide you any other counsel. You will simply have to represent yourself.
All right.
So you're telling me that the state's offer is 5 years DOC?
68.4 months.
68.4 months. And you're saying because the charge is a third-degree felony, it says it cannot exceed 5 years?
That's what it said.
And Mr. Williams is telling you that, in his opinion, you should accept the 68.5 months.
Yeah, he said I should accept the 68.4 months. I got to know where I'm at and realize what's going on. And I'm Pacific. I'm gonna say it Pacific like he said it. She's white, you're black. Understand where you're at. It's not gonna go the way you're thinking. You really think they're going to listen to you? You think they're going to listen to anything you have to say with your record and all that? Like, there's no way you should be my lawyer saying nothing like that at all to your client.
All right, Mr. Williams, anything in response?
Yes, Your Honor. I guess I'll start with that most recent statement made. Of course, I categorically deny that. I would have never said anything like that. The only time the whole subject of racism, if you will, came up was when he brought it up that he felt like he was a very racist town and that he wouldn't get a fair shake. And my only response to him was, I have not.
Testimonies begin, and already the cracks start to show. One witness stumbles under pressure as the defense fires rapid questions. There's a subtle but undeniable shift in the courtroom energy, and it's clear the attorneys are playing hardball. You can almost feel the moment everyone realizes this trial is going to get ugly.
That experience in Gulf County that it was racist. With regard to the maximum punishment, the reason first of all, we have two cases. They're both third-degree felonies. So I'm not sure Mr. Davis understands, although I tried to get him to understand, that each one of those cases as a third-degree felony carries a 5-year maximum. So when you total them up, which is what his total exposure would be, it's 10 years. The reason that the state's offer is so high, what initially you might think is so high, is because of his priors. prior record here. The score sheet, that's he scores out to 68 point something months. But you know, I never told him nobody would ever believe him, that sort of thing. I said, you know, we basically discussed what his side of the story was, so to speak, and I just said, well, what about this with regard to the evidence? And then I said, well, what about this piece of evidence? How do you think the jury is going to react to this? How do you think the jury will react to that? I was basically just trying to get him to see what happens when you get into a courtroom with the jury present and the presentation of the evidence. It's just the kind of conversation that I and other defense counsel have with practically every client.
Yes.
Okay. Yes, sir. Mr. Davis.
Okay. So, the conversation where he said, the other case that you have that you caught here in the jail, he said, that's going to hang over your head. We're going to deal with this charge first. This is the charge that we're at right now. The other charge is going to hang over your head. And sooner or later, once you get over trial, whether you more likely lose, they're going to throw that charge out. The charge is going to be threw out. They just want you to accept this charge. That's what he said to me. This man is continuously on the screen lying to y'all. This man is like very incompetent. The man can't.
Here, the prosecution introduces key evidence, but it backfires. A simple detail gets picked apart, and the defense jumps on it like a hawk. The courtroom watches in silence as the prosecutor fumbles for footing. It's the first time doubt enters the equation, and it won't be the last.
He came in up being rude off bat. He came in up being rude. It took me a minute, but I was calm. I was very calm with the man. The man told me, he come out and he tell the officer, oh, we're having communication issues. No, there are no communication issues. You're sitting here trying to tell me to take something, and then you're trying to lie and fabricate it and make it seem good in your little way. But that's not the case. Everything I told him, I say, hey, listen, half of these charges that are on my score sheet are not me. It did not happen. I received 2 different sets of charges of priors that was not my priors. He said, oh, we'll deal with that when we get in the courtroom. Haven't yet to say anything about it. Then you tell me, what he said. He said, I told him I said, I have a felony battery. I should not have a felony battery on this charge. It's caused of the mess. We'll get to that later. We'll get to all of that later. We'll deal with all that when it comes. We're not going to deal with that right now. We're talking. No, this is the charge that I'm on. Every time I tell him about something, that doesn't matter. That doesn't matter. That doesn't matter. How you going to tell me something don't matter? If it matters to me, it matters. You can't tell me something don't matter. You're supposed to be my lawyer. You ain't even representing me right. They just sit up there on the screen and try to lie, to try to make it seem good in your eyes. Come on, man.
What specifically about the felony battery? You said it should not be a felony battery.
Okay, I have a felony battery. And I've talked to my people. My people have been in contact with lawyers. They've been in contact with the state attorney down there in West Palm, where I'm from. And they have said, you have a felony battery, which you should not have a felony battery if y'all was living under the same roof. And both, if you claim she hit you, she claim you hit her, both of y'all should be arrested. Neither one, Drew is arrested, not her. And you have a felony battery, which should not be. It should be a domestic violence charge. I don't have no prior domestic violences. I have none of that on my record.
Are you talking about a pending charge right now?
I'm talking about the felony battery I have right now pending.
Okay, I have the battery in detention facility. What's the felony battery charge number?
2442, Your Honor.
And what does West Palm Beach have to do with this?
That's where my mom's at right now, and that's where she's talking to lawyers and getting in contact with people down there. I'm trying to figure out what's going on up here, because she's been trying to contact people up here and it's not working. Nobody's calling her back. Nobody's emailing back. When I had Mr. Hill, my family was trying to get in contact with him. They never could get in contact with him. My family, I've tried to get his information. He told me he didn't have any cards to give me.
If I could, Your Honor.
Mr. Hill, I talked to Mr. Hill priorly. When I talked to Mr. Hill said, I checked that you don't have any prior batteries. But then next thing you know, I get a prior.
Cross-examination intensifies. A witness grows defensive, the defense attorney circles like a shark, and the judge finally steps in. But not before the damage is done. A previously solid testimony now feels riddled with holes. You can tell the jury is paying closer attention than ever.
With prior batteries on it. Like,
the state's not charging you with felony battery based on priors. They're charging with felony battery, saying that you caused
I
great
understand
bodily
that.
harm.
That's what we're talking. That's what we talked about the first time. But I'm saying my score sheet, as he just said, my score sheet, I should not score out to that much because I don't even have none of them priors. I have about 4 or 5 or 6 priors that are me on them. They don't even have the priors that I went to prison for on them. That's how I know you're just trying to stack charges and trying to make it look like something that it's not.
Well, when you're telling me that Mr. Williams is not rendering competent and constitutionally effective counsel, I need to go issue by issue. That's why I'm at. You raised something about a felony battery.
Uh-huh.
What about your charge of felony battery? That you're saying your mom or someone from Fort Lauderdale disagrees that you should be charged with that? West Palm Beach.
She don't disagree. She's saying it's wrong. It is wrong. And we are staying under the same household and we had sexual relations. It should not be a felony battery. And especially if I said that she hit me and she say I hit her, they don't take her to jail, but then they take me.
That's a question. That's a question for the jury.
That's but it's not a question if it's a wrongful charge. You have me with the wrong charge.
Mr. Davis, listen.
Here, all you have to do is look at the paperwork.
Mr. Davis, whether you're living in the same house with someone or not, you can be charged with felony battery.
Are you sure?
Listen to me, Mr. Davis.
I mean, I have the evidence. I have the proof. I mean, if I'm looking it up and I'm finding this, my people are looking it up and they're finding it. And they're asking other lawyers and other state attorneys, and they're saying the same thing. Y'all are going to say something different from what everybody else is saying. This is for the whole state of Florida. I've been on the phone constantly.
I agree with you.
I've been talking to people constantly. You cannot charge me with a felony battery. Felony battery is like if I go off out there and go to hit somebody. That's a felony battery. If it's somebody that I'm living under the same roof with, and we're having sexual relations, because it's what it said. I mean, I've read up on it. I had my people look up on it. They've read it to me. I've written it down. I've talked to my people. It's a DMD. So I don't get.
Tension peaks as the victim's relative takes the stand. Emotions run high, and for the first time, the courtroom goes silent in respect. But just as things turn heartfelt, the opposing counsel strikes with cold, calculated questions. It's a brutal clash of emotion versus strategy.
Why y'all having with felony battery when it's not supposed to be a felony battery?
So you're under some lawyers telling you that listen to me. I'm trying to understand. Your family or a lawyer or whoever they're talking to is telling you, regardless of the amount of damage that you allegedly cause, that you can cause permanent disfigurement, great bodily harm.
No
I'm not saying you did. Listen to me.
I walk in this courtroom 10 times.
Mr. Davis.
Come on, man.
Do you want to have this conversation to get through this, or you want to tell me what you want to tell me?
The conversation don't seem like it's being understood by nobody. Because you tell me, oh, it don't matter this. I'm telling you, if I'm giving you this, and you're trying to give me something else, but I'm giving you what the law says. I've read in the law books and all. I've been in the law books. My people are looking it up and getting the same thing. You're trying to tell me something different to make me think that, oh, no, what you're saying is not right. When I know it is. If everybody's looking it up, I have different people looking it up out there. Everybody's telling me the same thing. I have people in here look it up. I've looked it up. I've even talked to Mr. Hill about it. I should not have a felony battery. There's no way I should have a felony battery on this charge. No way. And then they talking about my priors. That's not even me. Then you said, you should just take the charge. There's no way I should just take the charge.
We're going to get to your priors. Let's stick with the felony battery. Are you finished?
That's what we're talking about.
Are you finished?
My priors leads up to that felony battery.
Are you finished?
Come on.
Are you finished?
Come on.
If you're going to have a conversation with anyone, a part of it is listening, okay? I'll listen to you. Listen to me.
I'm listening.
You can be charged with felony battery based on 2 things, Mr. Davis. Felony battery based on priors. The state has not charged you with felony battery based on priors. They charged you with felony battery based on great bodily harm or permanent disfigurement. And it doesn't matter if you 2 live together or not. Now, if you're saying that whatever harm the state is alleging doesn't rise to that level, that's a question for the jury. Okay?
Can I say something again?
Yes, sir.
Okay, so we're going to go back to what you just said now. We're going back to what you just said in the beginning. They're not charging me on my priors. I know that. Okay? But they're trying to sentence me on my priors.
This is the moment a major contradiction surfaces. A witness changes their timeline and it's caught instantly. You can see the realization hit the room like a wave. The judge leans in. The attorneys take notes. What seemed like a small error may have just flipped the momentum.
Okay.
We haven't got to
And
that
you
point
saying-
yet. We haven't got to.
You literally just.
We're
brought up
talking
the
about
prize
felony
of-
battery.
the talk.
We haven't got to
Okay.
the score sheet.
So we're going to talk about this.
Yes.
Okay. So now we're going to talk about felony battery, right? You saying no matter the disfigurement or the bodily harm, you yourself.
I didn't say no matter the
Yes,
disfigurement.
you said no matter the disfigurement that if I cause disfigurement and all of that,
Permanent
for the
disfigurement.
jury, but you yourself watched her walk in this courtroom, as well as other officers walk in this courtroom, get out stomping. You've even said
I don't
something
know
to her.
who you're talking about.
You've even said something to her when I was standing up here.
I
You
can
said-
say something to whoever I want to.
You see,
But listen to me, Mr.
See, now
Davis.
you're just trying to, okay.
I don't know
Now you
who
want
the
me to be quiet.
I don't
I'm
know
saying
who-
too much.
I don't know who the victim is. I don't know what the
I'm
allegations
telling you.
are.
I'm telling you now.
Okay.
When she sat right there, and I was standing up here, her and her sister went to snickering and everything, you said something to her. Y'all gonna have to get out of this courtroom, get out of here. We're not with all of that. And they got up and walked out.
Okay.
You telling me you didn't see none of that? You haven't seen and watched nothing. You don't even remember that. Not even remotely remember that at all. I'm talking to you man to man, not judge the inmate. I'm talking to you man to man. Like, you telling me you haven't seen that?
Well, let me clear that up. This is judge to inmate.
I'm about to worry about it. Man, listen, we're men. I'm asking you a simple question. Did you or did you not see her sitting there when you said something to her, get up and stomp off?
Have you received a copy of your score sheet?
Yes.
And what
I like how you stopped that.
priors on your score sheet you say are not yours?
A bunch of them. As I've said to him on the first time he sent the score sheet and the second time he sent the score sheet.
Have you explained to Mr. Williams what priors on your score sheet you believe are not yours?
Yes.
Mr. Williams, you want
As
to
I
respond?
explained to Mr. Hill too.
Mr.
Yes,
Williams, you want to
sure.
respond to the score sheet issue?
Yes, Your Honor. We went through the score sheet, and I went down the score sheet with regard to his priors, offense by offense, and I took notes to the ones. There were 2 or 3 to my recollection. I don't have notes in front of me. He basically felt there 2 or 3 of them were not him. I said, and I marked those.
You're lying.
Mr. Davis, don't interrupt.
Oh, hey, listen. Just take him off my case. I don't want to talk about it more. Just take the man off my case. I'll do what I got to do now. Just take him off my case.
The courtroom dives deep into the defendant's past. Old records, past charges, and unsettling patterns come to light. Some jurors glance at each other, and even the judge raises an eyebrow. Every sentence from the prosecution feels like another nail in the coffin.
Mr. Williams, continue.
Take him off the case, man. I don't want to talk about him. He's lying. You're going to continue to listen to this man lying, man. Don't
As I recall, there were
I'm
approximately.
going to ask you one more time. Don't interrupt. We're in the courtroom. Just be respectful.
I don't want to talk about it no more.
Whether you want to talk about it or not,
I just want him off my case.
I have a legal obligation to go through this hearing with
Him
you.
off my case.
Mr. Williams, continue.
Yes, Your Honor. As I recall, there were approximately 10 or so priors. There were enough that on the supplemental score sheet, it was full, as well as the space on the first page of the score sheet. And I went through each and every one of those with Mr. Davis and asked him, because he had made sort of a general avowal that some of them were not him. He wasn't involved in them. They shouldn't be on a score sheet. I said, okay, let's go through them. I went through every one of them. As I recall, there were 2 or 3 that he said, that's not me. I didn't do that. I was never convicted of that. So I took those notes and I told him, okay, I can't give you an answer right now. I'll look into it. And before we go to trial, this will get resolved. I didn't have the resources to look it up right then in the jail. So that's the long and the short of it.
Have you reached out to the state to confirm whether or not the priors on the score sheet are actually Mr. Davis?
I have not, Your Honor. I saw this was a meeting in the jail that I had with Mr. Davis. I believe it was last Thursday, and I haven't had the opportunity to reach out to the state as I'm out of town right now. I went out of town on Friday and haven't returned yet. But of course, that is my plan, to reach out to the state and even to, conduct independent sort of investigation with regard to it if I have to.
A surprise witness is introduced, and you can feel the collective gasp. No one expected this person to appear, least of all the defense. What follows is a carefully calculated testimony that feels like a turning point. It's one of those moments that leaves everyone stunned.
Okay. All right, Mr. Davis, anything else?
Take him off my case.
All right, Mr. Williams, anything else?
Nothing, Your Honor. Just the first thing that you were discussing with him with regard to the felony battery thing. That's just his position. I think he finally made it clear is that he believes, since he was in a domestic situation with the alleged victim, that therefore the maximum charge.
I want to know domestic situation. Don't say that, because I ain't say that.
Is a misdemeanor domestic battery. So I explained to him that when the state charges great bodily harm, it doesn't matter what kind of relationship you have with the victim, it's a felony.
You said that? You said that to me?
Thank you, Mr. Williams.
Okay, I thought so.
All right, Mr. Davis, on the issue you raised, the felony battery, I've told you what the law is. Regardless, the state's not charging with felony battery based on priors, and regardless.
But y'all have your own law here?
I'm going to ask you one last time.
Okay.
Don't interrupt me. You do it again, you're going to be escorted out of the courtroom.
I'm going to go anyway.
Mr. Deputy Tober, you can get him out of here.
Hey, but I'm going to push. Hey, don't push me.
All right, as to the felony battery, the state's charged him with felony battery based on great bodily harm, permanent disability, or permanent disfigurement, not based on priors. The priors on the score sheet, Mr. Williams, you indicate you two did have that conversation. You're going to conduct an independent investigation. Also reach out to the state to confirm whether or not the priors on the score sheet are actually Mr. Davis's. As to the credibility issue, if it's her word versus his word, that does come down to the jury making that decision. On the racial terms, you tell me you did not make those comments, and your opinion of whether or not he needs to accept the plea offer is not ineffective. So based on what I heard today, I'm not going to discharge Mr. Williams. I'm not going to find that he is rendering ineffective assistance of counsel. And that'll conclude the Nelson hearing. Anything else on this case today?
That's nothing else from me, Your Honor.
The defense fights back hard. With renewed energy, they dismantle the witness's credibility, piece by piece. It's a masterclass in courtroom strategy, and it throws the entire testimony into question. The jury watches, wide-eyed, as momentum shifts once again.
Except I would request that just in case we do get a resolution before the October 28th, that we come back on that October 25th date as well.
Yes. And I'm also need to put on the record that Mr. Davis was disruptive of the proceedings, and he was removed from the courtroom prior to the conclusion of the Nelson hearing. We'll come back on October 25th for trial management, and we'll have jury selection October 28th.
And that October 25th, I believe you said, was at 9:30 Eastern time?
Yes, 9:30 Eastern time.
Thank you, Your Honor. You have a good day.
You as well, sir.
It looks like Mr. Cooper's on. Mr. Cooper, if you'll turn your video and audio on.
Good morning, Your Honor.
Good morning, sir. If you haven't, there's your video. All right, we're this State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper, you're representing yourself. You wish to continue to represent yourself?
Yes, Your Honor.
Okay, Mr. White, we're set for jury selection. Where are we at?
Your Honor, the state would move for a continuance.
Mr. Cooper, any objection?
Yes, Your Honor, being how long it's been, right? It's been over 7 years. They've already had a previous continuance.
Where are you at right now?
Ocala.
If you want to pick a jury, you need to be here in Panama City right now.
And I can be there as soon as tomorrow. I just wasn't sure because at the last pretrial hearing, the state said it wasn't sure where it was at.
We pick. Let me just explain to you. We pick juries on Monday morning.
Okay.
We don't pick them. We don't pick them any day, and we start at 8:30. So there's no way you could pick a jury today.
Okay. I just would like to say.
Now things get technical. Forensic evidence is brought forward, and experts start to testify. Charts, data, timelines, it's dense but crucial. This is where the truth either shines or crumbles under scrutiny. And it's clear, Both sides came prepared for this moment.
At the last pretrial hearing, the state wasn't sure where they were at with this case, and Mr. White wasn't there, and he recently was assigned to this case. And I also reached out to his office 3 times last week to try to inquire where we were at. So it did seem like the jury selection, I guess, was going to be taking place today. So,
well, I mean, I would be sympathetic to your objection if you were here in the courtroom. But you're not in the courtroom. I can't pick a jury. I'm not going to pick a jury with you on Zoom. You can't get from Ocala to Panama City in time to pick a jury today.
I agree. Yes, sir.
Okay. So based on that, I'm going to grant the state's motion. Since they made the motion for continuance, I'll charge it for them. But since you're not present, there's not much of an objection. Let's set it for a certain trial date. And Mr. White, Mr. Cooper, I mean, I know it's difficult for the state to communicate with a pro se litigant, and I understand their reluctance. I don't blame them. What we'll do is we'll set it for a date certain. When you want to set it? July, August? Since this is out of custody, it's an older case, probably the oldest case we have.
Set it for August, Your Honor.
That's August 4th?
Yes, Your Honor.
August 4th at 8:30. We're going to set it for a trial management June the 20th
June 20th, yes, Your Honor.
at 1:30 for trial management. And that'll give us sufficient time to make sure that case is going to make the cut. Okay, Mr. Cooper?
Okay. And it's okay if I appear by Zoom on the next trial management, but plan to be there for
On
the
that trial management date. On that trial management date, yes, sir, you can appear by Zoom. But if on a jury selection day, unless you know you're not going to pick a jury, you need to be present. Okay?
Yes, Your Honor. I haven't spoken to the state at all at any time for the whole 7 years of this case, and I know there's no law or any rule against it, so I don't know why it would be not maybe suggested some sort of communication between the parties. It just seems interesting. It's been so long.
The problem is you're a pro se litigant, and I'll be honest, if I was practicing law, I'd be reluctant to speak to a pro se litigant. Mr. White's going to have to figure out how the best way to do it. And it may be in writing. Mr. Sullivan?
Or when Mr. Cooper, if he shows up to court, I mean, typically we speak to pro se.
In this part, a moment of pure suspense unfolds. A juror reacts noticeably during a shocking piece of evidence. The attorneys notice. The judge notices. Cameras catch it. And suddenly, the trial isn't just about facts anymore, it's about perception, and that changes everything.
The litigants on the record in court, that's typically how it's done. So our office has no problem doing that, but outside of that, it most likely won't happen.
Or written communication. Okay?
Sure. And as far as I understand it, the worst that could happen is something could be used against me, was the way I understand. I might speak about something, right, that could be used against me. But I do believe the state could have, returned to my call anytime this week and said, we're ready for a trial.
They could have, but they're not bound to.
Sure, I agree with that.
Does that make sense?
Yes, I just wanted to make it clear that's the only reason why I wasn't there, thinking that we were going to proceed being with the new. Okay.
All right. Well, we'll see you in June, and like I say, you can reach out. Maybe reach out to them in writing. Okay.
Well, yeah, I won't now. I'll just see you in June and plan for August.
All right. Very good. That'll conclude today's hearing. Mr. Sullivan, you represent the state on this?
Yes.
All right, this is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. I have received information. Cooper is on Zoom. Let's connect to that.
Closing statements are on the horizon, but the drama isn't over yet. An objection explodes into a heated exchange. The judge bangs the gavel. The courtroom is tense. Everyone feels it. We're approaching the climax. But this moment right here, this is the fire before the final storm.
Cooper, can you hear me?
Yes, Your Honor. Good morning.
All right, this is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. This is here today on an order setting hearing on a notice of expiration of speedy trial. The hearing indicated all parties would be appear in person. I've not waived anybody's presence. Mr. Cooper, I've received a text from my assistant that you've asked to waive your presence. I'm going to deny that. The last time we had court, you failed to appear, contacted my office and said you'd overslept. The state had asked for a continuance. I had placed the case on the trial docket for August. You filed an expiration of speedy trial. We set the hearing today. It's not within the time period, but based on the case law, it's what we had to do. But you're not present. What's the state's position?
No, I don't believe the filing filed by the defendant was proper. I believe the notice of expiration of speedy trial is properly filed after a demand for speedy trial. There wasn't a demand filed in this case because that starts the recapture period. And then the notice of expiration should be filed at the end of that recapture period if he hasn't been brought to trial. Additionally, as Your Honor just pointed out, Mr. Cooper failed to appear at his last court date. That's not the first time Mr. Cooper failed to appear. And we actually had this case set for trial once previously, and Mr. Cooper didn't show up for jury selection that morning. So I would ask that the court strike the file.
Mr. Cooper?
Well, this is in regards to after the bond was submitted,
I want to hear your position on not being present this morning, because I required your presence and you're not present. This is an adversarial hearing. It's your notice of expiration of speedy trial. I set the hearing.
Yes, Your Honor. I live in Ocala, and with less than 24 hours to be able to get there, there was just no way I could make it there in that limited amount of time.
It was based on your motion that was filed.
But Your Honor, that was on June 31st or 30th.
I set the hearing and required that you be here. Also, you weren't present. You didn't even appear by Zoom at the last trial management.
I was on Zoom. I just had fallen asleep, but...
The prosecution delivers a passionate closing argument. Every word is calculated, every pause intentional. They tie together the timeline, evidence, and emotion in a final plea to the jury. It's powerful, gripping, and exactly what they need if they want to seal the deal.
Made it in time to be able to
call
call
it. So when the case was called, you weren't available.
I was on Zoom, and I believe all it was to confirm that the trial was supposed to be set for August 4th.
But you were asleep and did not appear. Is that correct?
No, I was on Zoom.
But you were asleep and didn't appear at that hearing. Is that correct?
No, I was logged in on Zoom.
Well, you just said you were asleep.
Right, but that's why I had to call Ms. Nelson, and she confirmed that it was okay and that I just needed to appear at the next one.
No, what was okay is I didn't issue it wasn't okay that you missed it. It was okay that I didn't issue a capias. But what I'm going to do is I'm going to, based on your failure to appear today, I'm going to strike the plea. And I would direct the state, you may want to file a response to this.
Yes, Your Honor.
Is that what I would be what you might want to do?
Yes, Your
I'm
Honor.
going to leave it on the docket for August, the trial docket. And, but I'm striking the plea today is for Mr. Cooper's failure to appear. I'm not going to waive his presence. I'm not going to waive your presence for the next court date either.
Your Honor, I would ask I understand the court's attention on the ruling, but before the court issues any potential written order on that, allow me tomorrow to file that response, so that at least the response is before the court, before you.
Right now I'm just striking for his failure to appear.
Yes, Your Honor.
All right, anything else?
Yes, I just object to that because regardless, the expiration has taken place multiple times, and we're way beyond the 170 days.
Well, let me put on the record how many times you've missed court, and I've issued cases.
Respectfully, Your Honor, the speedy trial time has still commenced since the bond was reinstated.
10/27. Listen, hush. On 10/27/19, notice of expiration of speedy trial, pro se. 11/7/19, demand for speedy trial by counsel, counter calling demand. On 11/12/19, trial set for 12/2/19. 11/13/19, motion for discharge.
Now it's the defense's turn. Calm, focused, and controlled, they paint an entirely different picture. Reasonable doubt, inconsistencies, gaps in logic. The courtroom listens, holding its breath. This isn't just a speech. It's their final attempt to flip the outcome.
For lack of speedy trial, pro se. 12/2/19, defendant was in court. Ms. Grabner filed a 60-day demand. I set the
Which
trial,
should have been
jury
struck
trial
as
once.
invalid
Listen,
also.
don't interrupt me again. Set for jury trial 1/6/20. Set it for pre-trial 12/17/19. The defendant did not appear, filed a pro se waiver of appearance. Defendant not present, filed a pro se written waiver of presence, even though represented by counsel. A capias was issued on 12/17/19 for defendant's failure to appear for trial management. On 1/31/20, certification of conflict, officer criminal conflict appointed. 7/14, waiver of right to counsel filed. 7/31/20, order dismissing pro se filings. 3/15/23, capias executed in Marion County. Defendant present and out of custody. 7/11/23, I allowed you to appear by Zoom. I would not accept any more pro se filings since you were represented by counsel. On 7/21/23, you were allowed to represent yourself. Fourth 9/24, capias issued for failure to appear for pretrial conference. Notice of expiration was filed for speedy trial 5/9/24. Hearing was set on 5/14/24. You were in jail in Marion County. Five 24/24, order denying motion for discharge. 5/26/24, capias was issued, executed. 5/28, it was first appearance before Judge Kramer. 5/28/24, order denying motion for discharge. Same as 5/24/24, no order. 5/31/24, renewed motion for discharge, expiration of speedy trial. That was denied on May 31st/24. 6/6/24, motion to discharge, denied 6/6/24. And on 5/5, you appear by Zoom, ask for state ask. Then on 5/5, you weren't present on the trial selection. You were in Ocala the day we were picking juries. On the 6/20 pretrial, you were not in the Zoom room. You say you were, but you were asleep. Now we're at today's exit.
The verdict is near. The courtroom is silent. Every eye is on the jury as they return. You can feel the weight of it. A hush falls. Then, the decision is read and reactions erupt. This final moment seals the fate of everyone involved. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.